So welcome everybody. My name is Felicity Stedman and I'm a director and mediator and trainer with Conflict Dynamics. At Conflict Dynamics, we believe in mediation and we have been working as mediators for very many years, mediating and training mediators. We practice mediation alongside our professional careers, and we have 4 consummate professionals with us today who are all trained conflict dynamics mediators and who are lawyers, because the focus of our conversation today is what lawyers need to know about mediation and Rule 41A. So very briefly, to introduce our 4 lawyer mediators, we have Chris Todd, who is going to moderate the conversation with our other 3 colleagues, and he is an attorney and partner at Bowman's and has been an acting judge in the Gauteng High Court. Tefo Raditapole is an attorney, partner and chair of the Cheadle Thompson and Haysom group of attorneys. He's been an advisor and a board member to numerous large and local international organizations on questions of conflict and conflict management. Lee Souza Spagnoletti is an attorney with a focus on family and intellectual law at Lee de Souza. She's also been an acting judge in the Gauteng High Court. And Patrick Deal is an attorney at Deal Attorneys and has been an acting judge in the Labour Court. So we have an eminently qualified group of mediators who are also attorneys and have worked in the courts and understand how mediation might be helpful in the dispute resolution process. In a moment, I'm going to hand over to Chris, and while we can't see you and you can see us, what we will be able to see is any questions or comments that you might have. Please put those in the Q&A or in the chat, and we will answer them as we go along. And then finally, just to confirm that we are recording the session and it will be made available in due course on the Conflict Dynamics website. So thanks everybody for joining us. We're very pleased to have you, and I'm going to hand over to Chris now.
Thank you very much, Felicity, and welcome to everybody again. As Felicity said, I'm a partner practicing attorney, and I've been at Bowman's for around about 30 years, trained as a mediator in around 2008. And since then, although I have been appointed and have served as a mediator from time to time, I've spent used my skills that I've gained through that process much more often advising clients and in the course of trying to help them navigate disputes and to pick the most appropriate ways of tackling disputes. What has been apparent in the years since then is that pressure on us as lawyers to understand mediation, to promote it, to participate in mediation, and to be effective in how we participate in mediation is growing, and it's continuing to grow. Sometimes the reasons for it growing are, for me, not the best reasons. Being told that the reason why we should be interested in mediation is the overburdened court roles is a relevant consideration, because our clients are very interested in how long it's going to take their disputes to be resolved. But it's not my favorite reason, because that forgets about the opportunities that mediation presents and that negotiating presents, what I generally refer to as consensual dispute resolution presents, to actually achieve outcomes that can't be achieved through court litigation. But what, at the same time as pressure on us is growing, it's also apparent, and it's really been an ongoing theme, that lawyers, we as practitioners, are perceived to be, perhaps sometimes are, obstacles to the growth in mediation or the use of mediation as part of an effective dispute resolution system. So that's something which it seems to me, if we are primarily a group of lawyers here talking today, we should be concerned about. And of course, that's because our main purpose and professional duty is to our clients. And one would assume that as lawyers, we would use whatever modern, effective, best practice tools are available in the dispute resolution toolkit to pursue the interest of those clients as vigorously as possible. So the good thing for me today is that I'm not supposed to be doing all the talking, and I'm really going to be asking the questions. And I'm delighted I'm not going to reintroduce the panelists that Felicity's introduced, but we'll come to them each in turn. Therefore, if I can start with you, not all of us are as familiar with mediation as each other. I said I've trained in 2008, but I'm learning all the time, more as one goes along about mediation. But perhaps it is useful to just start with a general discussion about what mediation is and perhaps isn't, and why it is a useful sort of tool, dispute resolution tool in the toolkit of an attorney. I see you're still on mute, therefore, and I don't want to tell you every time to go on and off, but before, let me preempt that. Can you kind of just talk us through some of the basics?
Okay, thank you, Chris, and good afternoon to everyone. Well, what is mediation? Mediation is a voluntary process where parties to a dispute choose a third party, an impartial third party, to assist them to reach agreement. In other words, it's a consensus building process where that enables parties to craft their own outcome with an assistance of this impartial third party. And I do use the word impartial advisedly because mediators are not neutral. People tend to think mediators are neutral, that we are not. We never are. We always have a view, but we need to manage those views that we have and be true to the concept of impartiality. So the mediator in no way imposes any aspect of the substantive issues on the parties to the dispute. So the mediator then, in the mediator's role then is simply to facilitate the conversations between the parties to help them reach a mutually acceptable agreement. What the mediator's role is not to judge, it's not to advise, and particularly in the context of Rule 41A, it's not to make rulings either. There appears to be some expectations that a mediator may make rulings in the process. That is not the job of a mediator. The job is exactly as I've described it, is to assist the parties. Neither is it to advise or recommend. The mediator manages the process. He or she is a process manager and makes process decisions.
Therefore, can I know I don't want to interrupt you, but just coming to this point about mediators not making decisions or rulings. I have had experience of colleagues who've come to me and said, we picked this fantastic mediator, and the mediator had all of these credentials, and we picked the person because they were experienced in this type of insurance litigation or whatever it was. And we were just disappointed that they didn't, in fact, what they're normally disappointed about, we were disappointed that they didn't tell the other side that they were being unrealistic, and they didn't give us the kind of assurances we were looking for about our case. But can you just talk a little bit more about that? I mean, how a mediator manages the fact that they're sometimes chosen because they are senior or have stature or experience in the field, but the process doesn't require them to assert that part of their professional experience.
Yeah, one of the mediator's jobs is inside meetings, particularly, so this is not done in a joint meeting, is to assist the parties to understand the reality of their situation. They come into the mediation, or they would have gone into litigation with particular positions, strong positions, possibly as advised by lawyers and so on. But the mediator's role is to help them understand the real situation, to help them understand the other parties' positions, as well as underlying interests, to help the party themselves understand their own underlying interests, which often they don't quite understand, especially in a litigious situation. So a mediator can reality test and do these kinds of things, but in the safety of a side meeting where the other party isn't present. Having said so, the job is still to guide the parties to agreement. It would never be to use whatever forceful nature they have in litigating to pressurize the parties to go in one direction or another. I think that's the best way I can answer your question.
No, that's great. And it does say to me that the point is that that a party, as you said, in a side meeting is not going to know what has been said in the other room. And if you have it's part of a mediator's toolkit to kind of reality test, stress test whether parties have got a good understanding of their case or not. But that was unlikely to happen in the presence of the other, or within the sort of, there's no put down in a general meeting of one side's case in front of the other.
Absolutely. In fact, what I would have wanted to start by to describe mediation is to use the orange example. I think everyone has mediated in their lives, especially parents who have children particularly. Now imagine two children fighting over an orange, and mom comes and says, what's going on? And the kids say, no, I want the orange, he wants the orange, and so on and so forth. And people usually say, okay, why don't you cut the orange in half, or why don't you take it away? But the truth is, if you mediate, what do? You ask the one child, why do you want the orange? They tell you, I'm baking a cake, I need to use the rind. The other child, why do you want the orange? I need to make juice. So what do? You squeeze the juice out, and the one child's interests are met, having a full glass of juice. You hand over the rind to the other kid to make the cake, and a cake is made because the full rind was required, as opposed to having cut the cake in half the orange in half and compromised and not met the interest of either of the kids. So essentially, that's what mediation is about.
Tefo, thank you for that example, because I've also heard people complain, or parties complain sometimes, that mediators essentially crank up the pressure to accept a kind of middle ground compromise where neither party's really happy and neither party's interests are settled. But you're saying that's not really the purpose of a mediation.
One of the big items in a mediator's toolkit is the ability to distinguish between positions and interests. And so, especially in litigious matters, of course, the pleadings set out all the parties' positions. What you need to do is dive underneath and discover what those interests are, which is exactly what the orange example tries to highlight. I'd like to touch on a couple of ground rules for mediation, if you don't mind, Chris.
Please, because this is how you do that. It's all very well to say you must uncover the party's interests, but how?
Yeah. So one of the key ground rules is about confidentiality. The mediation process in its totality is confidential. What would be said in joint meetings remains confidential. What is said in the side meetings is confidential also to that side meeting. And if there's information that needs to be conveyed that the mediator thinks would be helpful if the other party gets to know about and understand, then the mediator has to ask for consent, for permission to convey that information to the other party. So that's important, and that, if it's a golden rule really of mediation, that confidentiality. Then, of course, the other important ground rule is that the process is without prejudice and off the record. And the purpose of this ground rule is to enable, well, in fact, both ground rules really, is to enable the parties to communicate more freely, to make them more creative, explore more options without fearing that whatever they've raised would be used against them later or in another process. So that's quite important. And in this respect, the mediator also cannot be called to testify at a later point or in future proceedings. In fact, usually what we do is to tie up whatever notes we would have taken I've been in a very similar matter where somebody wanted to subpoena me, having done a mediation somewhere. And I said, look, I've forgotten everything. And they said, where's your notes? I said, I tore them up ages ago. So you may well end up declaring me a hostile witness because I won't remember anything. Essentially that's what it is. And of course, the mediation is voluntary. No one is compelled to stay in the mediation. If a party wants to leave for whatever reason, they are free to do so, even though the mediator will try very hard to convince the party to stay in because of what the potential benefits would be of staying in as opposed to going out. And having gotten to what the potential gains would be, I think it's important just to highlight that the beauty of mediation is that the parties craft their own solution at the end of the day, as opposed to that solution being imposed by a third party, such as a judge or an arbitrator. One of the real true beauties of mediation, and very often then relationships are preserved or even enhanced through this process of mediation, whether it's a commercial relationship or any other relationship. That was an important point to make. I'm not sure if you want anything more from me.
No, I want lots more from you, Tefo, but I think let's just pause at that point and just switch to a slightly different topic of conversation. Earlier, I talked about the toolkit. So those are some of the key things that are characteristics of a mediation and what make it work and what the ultimate objective to find an agreed solution. But I talked about a lawyer's toolkit, and Lee, maybe that's something to switch across to you. As lawyers, where does mediation fit into our toolkit? We tend to start with the rules of court and look through those. We have to know our way around the rules of court. Most people will know that there's been a mediation rule introduced to say you must just say up front whether you are or aren't game for mediation in an effort to resolve the dispute. But where does it fit in? How does it fit in? And where do lawyers actually get engaged with either a duty to consider mediation or to advise clients about it or otherwise?
So mediation historically in many fields is well entrenched, and it's been around for many years. So if you look in the family law fields, for example, or the labor field, it's already well entrenched in those fields, and it has shown success. When Rule 41A came in, it started to pervade other fields of law. And in relation to those fields of law, there's still there's a lack of familiarity in terms of what it is. So Tefo's explained quite nicely what it is. There's no finding, the mediators don't sit as judges. But I found that the question on everyone's lips is, well, yeah, how does it fit in, and how do we achieve mediation? So firstly, where does it fit in? Well, obviously you've got Rule 41A, but you've also got Rule 37 and 37A. And I think what's so incredibly important in our court rules currently is that I don't believe mediation will only be achieved via Rule 41A. I believe that if one reads 41A in conjunction with Rule 37 and 37A, I believe a time is fast coming where a court is actually going to order mediation. So like Tefo said, mediation is a voluntary process, but that doesn't mean that it cannot be ordered. So within the mediation itself, the parties control the mediation and they control where it goes. But I don't know, but I suspect somewhere that it's going to be our only hope. We're sitting with a wait of 5 to 6 years in our courts. We have clients who need speedy resolution. They're owed by the attorneys speedy resolution, and at the moment we're just not achieving that in our courts. So there are a lot of personal injury attorneys that are sitting in this room, and I do want to address them to an extent as well, to say that mediation is shown to be effective in that field. Pilot projects have taken place where things were slow, but it has shown that mediation can work. So how do you achieve it? I'm just going to give a bit of a background, and this applies to across the board in terms of fields of law. I am bringing applications under Rule 30A, and I'm getting my opponents to comply with court rules. But in addition to that court rule, I'm incorporating 41 and I'm saying you're obliged to state whether you're prepared to or not, and you're obliged to give reasons. And if you don't give those reasons, you can be compelled to give those reasons. So what the courts are readily doing in the applications that I brought, and I am talking to a great extent on a personal level, is they are saying you are required. So we are compelling you to give reasons for mediation. I believe that at some point a court will order mediation because Rule 37A deals with case management, which we can apply for at any time as an attorney. Doesn't have to be category Y matters. You can apply for case management. And once there is case management, it's very clear in 37A that the parties have an obligation to expedite the matter towards finalization. And for that reason, I believe the courts are going to, at some point, order mediation. But even if they don't, I have received many orders stating, give your reasons why you're not prepared to mediate. And I'm then faced with a situation where the opponents don't comply. And I then go back to court and I say, well, you've asked them to consider mediation. They're not complying. I want an order that if they don't consider it, their defense is struck. Now, this almost flies in the face of mediation because amicable settlement is first prize for all of us. But what the courts have shown to an extent is their disapproval of that refusal. And I've had several orders over the last year or two where if the opponent does not agree to consider mediation, their defense is struck. The sad thing is we're then going for default judgment. But I'm happy that the courts have shown what they've shown, and that is consider mediation or face consequences. So first prize is amicable settlement, and the courts are showing a willingness to facilitate that. The alternative is a 5 to 6 year wait for court dates. So I can tell you now that I'm pushing my clients either way. My opponents must consider mediation. If they don't consider mediation, I'm not going to wait for 6 years. I'm going to push them into giving reasons. And if they don't give those reasons, I'm then going to push to have their defense struck. I know it's not very mediator-like to say these things, but I believe that the only way to push into mediation is by way of Rule 30A and by putting applications to court to have parties order. The problem with costs in Rule 41A and the problem with mediation and the orders that have come out of our courts in recent years is I'm finding that the costs risk is neither here nor there. It's ineffective. So if you say to a party, well, either mediate or you're going to face a costs order, I don't know. I'm finding that it's not effective at all. Okay. So what becomes more effective is when you use Rule 30A and you push the parties into a situation where they must consider it effectively. And if they don't, they run the risk of a defense being struck. Now, one doesn't necessarily go that route in family law. In family law, it's more entrenched. And in family law, I find more of a willingness of the parties to mediate. But the biggest question I have on the lips of colleagues who contact me is, well, how do I get to mediation? What do I do to get it there? And the only thing I can say is it's not always easy, but it's not going to be achieved by Rule 40A on its own. I think one has to bring in Rule 37 and Rule 37A. And when one brings one's applications for mediation and compliance with other court rules, one has to incorporate the goals and aims that are set out in 37A as well.
Thank you very much, Lee. So, I hear you talk about those rules. I mean, of course, 40, you're going to get to the pretrial conference, even 41 at the start of litigation, the pretrial conference much later on.
Yes.
Why don't lawyers think about mediating, or their clients think about mediating even before that, before they even get into court?
So I think the main reason has been that mediation has not been on the lips of everyone. It's only fallen onto the lips of colleagues now with Rule 41A coming into operation. And I think it's also to a great extent the fact that historically, legal representatives are litigators. Not all of them, and not in family law and not in labor law, but in other fields of law, the easiest way to achieve resolution has been to obtain a trial date. But again, we sit with a situation where we're waiting 5 to 6 years. So why hasn't it been there? I don't think it's necessarily been at the forefront. And I don't think that the legal profession realizes how available it is or how effective the request for it is. Because like I said, we are getting court orders where if parties are refusing to consider mediation and they're refusing to comply with the rule, they are running the risk of defenses being struck. And this is terrible for the defendants who are sitting on the other side of the coin. You know, we've got a lot of parastatal type defendants who are overwhelmed and they don't have the means from a sheer volume perspective. And that needs to change. So the attitude towards mediation needs to change. It's an effective tool. The pilot projects that we were engaged in showed it to be a very effective tool. And I think this is what needs to be recognized by the profession as a whole, that it's a very effective and speedy tool to achieve resolution.
Well, let me be a little bit cynical for the moment then, Lee.
Okay.
If it's very effective and speedy, doesn't sound like a lot in it for me as the lawyer of a plaintiff facing a complicated personal injury case, or with a state institution who I might find I run a case against for 2 or 3 years, or even longer.
So I'm glad you've mentioned this, and this applies to both attorneys and advocates. At the end of the day, by the time we get to the point where we are applying for a trial date, 95% of the work is already done. And that has to be borne in mind. We've already, for example, with personal injury law, you've got your expert reports in, you've done everything, you've assessed and you've quantified the action. And now you're sitting for 5 years waiting for a trial date. So I think it's quite important to realize that in terms of where attorneys are losing out, well, to prepare for a mediation is very similar to preparing for a trial. You've still got to have all your expert evidence. You've got to assess your expert evidence. You've got to be prepared on the matter. You've got to be able to address and engage on what the case is. And the same applies for advocates. So if you have a situation where mediation does become, it does become more common in other fields of law, it's speedy. You can achieve mediation within a month or 2, as opposed to waiting the 5-6 years for a trial date. When it comes to advocates, I mean, one has to accept that attorneys can only present so many matters. I mean, I present my own matters before court. I'm happy to achieve resolution and to run trials and applications for default judgment without counsel. But the reality is I can only do so many. So when you look at the bigger firms who are running hundreds of trials a year, there is no way that those attorneys are going to be able to present mediations themselves. They're going to need the assistance of counsel. And then counsel has to prepare as well. So I don't see where the loss is. For me, there's only a plus. You're getting a second bite at the cherry. Let's say, for the sake of argument, mediation is not successful, but we have seen that in most cases it was. But let's say it's not. You've had an extra bite at the cherry much earlier than you would have. And mediation is much cheaper. I honestly believe that whether the attorney prepares or the counsel prepares, someone has to prepare. And, when it comes to mediation, you're looking at a day. You're not looking at 20 days. The issues are really crystallized. And what I can say I've seen in mediation as well, particularly with family law and with personal injury law, is that the parties are coming in knowing what they want. They know where the issues lie. They know exactly where the points of dispute are. And I'm finding, from a mediation perspective, you're not mediating for 20 days. You're mediating for a day, possibly 2 days on a complicated matter. I'm not seeing, even in the medical negligence field, I'm not seeing these mediations continuing for day after day. So from that perspective, it's much cheaper, but the preparation for the legal representative is still intense, and for counsel.
So I want to come back, Lee, to the question about whether or not we should be worried at all about whether lawyers are going to make their fees, because the alternative proposition, of course, is that you might, with really early mediation, be able to settle a matter with relatively little involvement of lawyers, and whether we care about that if the lawyers don't make their buck out of a trial. But I want to come back to that, because I think we know that lawyers' primary duties to clients, and I think it's a good opportunity to bring Patrick in to talk about how you talk to clients about assessing their interests, mediation versus litigation, and how as a legal representative we have to think about bringing that, the sort of the client's focus onto what the different scenarios are that they're facing. Is that
Yeah, Chris, I think the reality is most individuals in particular, and actually many corporates, many companies and so on, hopefully in their interest, don't encounter the law and legal disputes too often in their lives, sometimes one or two in their whole lives. So it's not something that they're familiar with. But they do have a lot of anecdotal information about court cases. They see a lot on movies. There are a lot of series about court cases and wrangles and tough lawyers and how things go and who's going to wallop who in court and that kind of thing. And so there's a lot of perception about law that in one way looks quite daunting. Well, it looks very daunting for any individual to go into a court. First of all, the whole setting of a court, of the judge up on high and the others, sort of at a lower level, and just it's an intimidating environment. And the thought of going into some kind of court case, just being sued in the first place, or suing or otherwise, is a daunting prospect that most individuals haven't experienced. And I think lawyers have a responsibility to say, listen, this is the road ahead. I've trod this road. I've been backwards and forwards on this many times. And I've got some thinking to share with you to enable you to make the right choices, because going to court is not the only choice. It's only one of several choices that are available to settle your dispute. And we have thought about basically the psychology of an individual going into such a dispute. And it's a kind of a semi-legal counseling type of thing for the counsel, for the well-being of the client, whether it be an individual or whether it be a big or small organization, or what they're letting themselves in for. And the main driver or the trigger of this anxiety basically is fear. It's fear of the unknown. Are they going to win or are they going to lose? Remembering that this is a binary thing. There's a one winner and there's one loser, and there's no one in between in a court case. And also, what will it do to reputations, personal reputations, corporate reputations, brand reputations, and those kinds of things. And also, the financial losses can be extraordinary, because once you start, particularly if you're a defendant, the clock starts ticking. Or even if you are a plaintiff, the clock equally obviously starts ticking. And if one of you wants to pull out during that, you've run up costs for your own. And if you sort of lose heart in continuing, you've got to consider paying the other party's costs in it. And so just starting on the venture is inherently risky, and the results are obviously unknown and up to a stranger, a judge who's no doubt well versed in these things, to make the decision. But anyway, you don't know which way it's going to go. So we have just developed some kind of risk assessment tool here, which was originally crafted in the labor sphere, but we've now adapted it for commercial disputes as well. But it's just to give an indication of the kind of road that a dispute would follow on the way. It looks very busy. Don't worry about that. I'll just take you through the top line and the vertical line here. The top line, well, first of all, there's an indicator there. It's a risk assessment tool. Low is a sort of a pale greeny color. The medium is the sort of orange, and the high is the red danger zone. This is where, obviously high risks. And the different processes that, something of dispute takes on its way to a final trial and a final judgment goes something like this. The first stage, going along the horizontal, Craig, if you can just point out there, there's the informal resolution stage. In other words, the pre-litigation stage. I think what Chris mentioned, is there an opportunity to have a discussion even before you start in the pre-litigation stage. And this is a negotiation or a mediation. If that doesn't do the job, the second phase is a pre-litigation stage and say, okay, well, look, we've had a talk, we've had a negotiation, we haven't agreed, we're going to demand now. And even at that stage, there is an opportunity for mediation. If that doesn't work, the next subsection is the pre-trial pleading stage, where the summons goes out, and now we're really in business, in the litigation business. Statements of defenses are exchanged, and then there's a reply, and there's a whole lot of backwards and forwards that goes on with documents and so on. The file gets fatter and fatter. The costs are rising and rising. And even at that stage, the parties at that point will kind of get a clearer idea about what each other's cases are about. The lawyers will have a better idea about what their case is about, how strong it is, how weak or strong or tepid it is, and also of the strength or otherwise of their opponent's case. And they might take a view and say, listen, this is really heading in the wrong direction. It's getting complicated. It's getting costly. We can pause for mediation. So they can take a break there, and they can mediate if they want to at that stage. If that doesn't work, then the final stage is obviously the actual trial itself. And even in the trial proceedings, you hear often of court cases which are settled literally at the door of the court. Why is that the case? Is that because people are taken to the brink? They're absolutely exhausted along the journey there. And at the court door, they think, no, actually, is this really worthwhile? In a sense, there's a bit of gamesmanship that goes on in any litigation. Are we going to call their bluff? Are they going to fold? And both are at the court door with their attorneys all lined up in their gowns and so on, waiting for the judge to arrive. And they say, listen, can't we just go and have a little chat in the corridor? It's another opportunity to have a look, to reassess whether or not you want to hand it over to the actual trial. And even if there is a trial and one or other loses, there's a potential appeal, then there's an opportunity for mediation. So all this tries to say is that there's a long journey here, and there are lots of opportunities to get some kind of rational discussion going. And the more you know about it, the more the factors arise along the way and become more intense, the greater the appetite for settlement becomes, because people only really start often trying to settle when they're feeling the pain, quite frankly. And they'll be feeling the pain when it gets to this kind of progress on a court case. And just briefly, some of the factors to consider along the way, and this is from the client's point of view, whether it's an individual client or it's a corporate client. Just look on the verticals there, Craig, on the description there. The first thing is the management time. I mean, if it's a corporate dispute. If it's an individual, obviously it's the individual's time. It's the degree of stress. I mean, these are worrying. People don't think of anything else when they're in that court. They wake up in the middle of the night thinking, God, how's this going to go? They're stressing out. They talk to other people. They can actually, it just becomes all-consuming for an individual to be faced with this sort of jungle of the unknown, with the tap continually dripping with costs, and the next bill comes in month after month after month from the lawyers. And then there's also the risk to damage of reputation, because remember, this goes out in public. It's the press love particular types of cases, and they seize upon them, and you lose control of the narrative once it goes to the press as an individual or a corporation. You can't control that narrative. You can't put cease and desist. Well, you can put cease and desists. You can do all sorts of things, but it goes out to the public. You lose control, and damage to reputation is a real thing. Obviously, the duration of the process. In a trial, we're talking 4 to 5 years, including an appeal, or even longer. Lee has talked about the time it takes. And in each case, the mediation phase, even after a long time, after each subsection, mediation is much, much quicker normally than obviously a trial at any stage. And then there are the legal and related costs, and then one of the primary things is the uncertainty of the outcome. You just don't know what the result is going to be. You don't have no control. As Tefo has said, you're leaving it up to someone else to decide for you. And that person is limited in the range of solutions or outcomes that can be determined. In other words, the judge is constrained by the law to a limited range of possibilities to resolve the dispute, payment of money or whatever. And so then it comes down to the other factors in mediation, by contrast, you can control the outcome. You can determine what the final solution is, and you can control the confidentiality and the reputation things much better than you can exposed to in this court proceedings. And so, if a client comes and says, "Well, this is what I do," I would suggest having a look at this array to say, "This is the choice. We can make decisions along the way. If you want to start, we can stop anytime. We can pause, and we can see what we can do." And the overall cost, just in this model of a standard civil case, just using, it's this indicator, is you can get 400,000, 500,000 rand for an individual corporation, depending on size. That's a sizable amount of money. So that's just Chris, the model that could be used at the beginning of a case to educate, or not so much educate in that sort of way, but to make a first-time litigator or a few-time litigator aware of what they're letting themselves in and what the cost, the time, the stress, and all of that would be. And I find it a useful decision, a useful way just to guide along the way. Look, if we want to start, are you still sure? You're still sure. I mean, I think, the other side of the scale would be to say, no, we're going to go in, we're going to take the sort of the tough lawyer approach, the bulldog approach they call the lawyer. We're going to go right through this process. I think we're going to win, we're going to think, and you lose at the end without having actually discussed these possibilities, without having discussed the scenarios and everything that goes with you. And when you get to the end of it, and your client is battered and bruised, financially distraught, and sitting on the street, that's a bit overdramatic, but unhappy that they were unaware about what they were letting themselves in for.
Patrick, thank you very much. I mean, when I first looked at that slide, it looked very busy, but the way I've heard three key things come out of it. One, your point that actually considering consensual dispute resolution, negotiation or mediation can happen at any time, right from the beginning, even before your pre-litigation phase, and at any stage throughout. That I found very interesting. Secondly, your heat map is great. I mean, look, these are not tools that we get in law school or even in many of our law firms. I don't think these kinds of things are regarded as bread and butter for the lawyers, but seeing it visually, how that heat map goes. And we've all we know how, as the cost and pressure increase, settlements towards the end or after an enormous amount is already sunk. And then the third thing, I loved you taking us through all those different things which we often don't think about are actually impacting in the sort of cost benefit analysis. So that sounds that's really interesting. Therefore, there's been a bit of a conversation in the chat and some questions about this question of lawyers in mediation. I mean, there are two things. One is about, and I said I'd come back to it with Lee in a moment, and let's park that for them and come back to Lee about whether it really is a good thing for lawyers to find effective dispute resolution. But therefore, the question about lawyers in mediation, I've heard different arguments about this. There's in some quarters a perception that lawyers ought to be kept away from mediation because they somehow are going to try and stay in control and manage the process and be in control of it in a way that's not going to facilitate a good negotiation. And then obviously the other view, which I think is certainly the predominant view of experienced mediators, but I'd be interested in your perception that lawyers, at least lawyers who understand the process and understand the interests that are at play on both sides of the table, can really help in mediation. Just experiences from your side, Tefo, about having lawyers in the mediation, in the room. Have you experienced both? Are they usually helpful?
I think particularly with litigious matters where papers and stuff have been served and so on, then lawyers are really your friends as a mediator. And one of the principles is to try and make sure everyone in the room participates, that you involve them in the conversation, so that there isn't one dominant. There isn't a dominant party at the expense of other people. But I think lawyers are better able to appreciate what's coming. But it's also important to explain the process properly so that people understand it, particularly those that are not familiar with the process. It's important to spend time explaining what the process is, how it works, what the mediator's role is. And I think when that understanding is there, it tends to reduce the sometimes obstructive nature of some lawyers. And can I say this, Chris? I meant to say it right at the beginning, and when Lee spoke, it struck me that I should have made the point. The other thing is, of course, you don't always settle every matter you mediate, as much as we do settle a lot. But even if you don't settle a matter in a Rule 41 situation, what you are able to do is to massively narrow the issues in the process. So you can, even without a settled an agreement on the substance of the dispute, you can absolutely have an agreement that lists all the narrowed issues and lists what the issues that are still in dispute are. So it's a helpful process either way, whether you get an agreement or not. Is a point I should have made earlier. So that's my bit on lawyers. I think generally lawyers are your friends in this kind of litigious situation. I think often it's not understanding the mediation process that often leads to people being possibly unintentionally obstructive.
Yes. Okay. So that, yeah, come in, Patrick.
Yeah, Chris. I mean, I agree with what Tefo is saying. You know, sometimes I think lawyers. I think it's a general perception that lawyers have got to be tough and they've got to be almost macho when they go into these cases and so on. You know, as I've talked about. I mean, there are extreme examples of the Stalingrad and the abuse of the courts and lawfare versus justice and those kinds of considerations. But there's and I think partly flowing from that as well is that if a lawyer suggests mediation, it's a sign of weakness. It sort of indicates that the lawyer doesn't have faith in the client's case. And somehow we need to get past that to say, listen, I think you've got a strong case, but this is what you're in for here. You know, and even though your case may be strong, I may think you're strong, your case is strong. I will support you all the way through. I really don't know what the outcome is. Let's suggest mediation anyway, because it's with or without prejudice and so on. It's opening the door to mediation. I think there's a major stumbling block or mental block, you know, that doesn't open the door to mediation as often and as freely as it should do, to explore it anyway, because then you can go back to your legal fight and your on the points of law. You know, if it doesn't work, it's always there. So, you know, I think that's a major stumbling block, is that who's going to go first? Who's going to blink first, almost, you know, in a litigation scrap like this, to suggest mediation. And I think if we can overcome that thing, that it's a bold move. It's an act of asserting confidence rather than a weakness to propose mediation. I would strongly think somehow that we can get that attitude across. It would be of value.
Yeah, I mean, Lee, can I just? I know you've posed the question and you've been dying to come in, but I want to put it like this. I mean, you know, answer say what you're going to say, but also please answer this. If it's in a client's interest to settle early, and it so happens that very little has happened by way of legal costs and legal action, isn't that fantastic for the clients? And do we even care about the lawyers? Aren't we supposed to be celebrating on behalf of the client whose interests are at the forefront?
Without a doubt, and I think it depends very much on the type of defendant that you're litigating against. So I've had quite a few messages as I'm as this webinar has been going on, and one main thread, firstly, is the costs of mediation, and secondly, how long it takes. So I just want to address those quickly. Firstly, I agree with what Patrick said. In terms of mediation, there's no need to be macho, and there's such the stigma that might be there needs to be removed. There are many people in this webinar currently who know what a staunch litigator I've been for 25 years. I've at times been quite a bombastic litigator, which I'm not proud of. But I think what is so unbelievably important is to point out not only the success of mediation, but the space that you move into when you mediate, because it is a different language. And it is shown to be effective. So, for example, and I'm going to address the road accident fund attorneys that are here and the personal injury guys again, the mediation space is so different to the negotiations that take place under pressure at court, because everyone is there to settle. And I've found that it's such a different space. The tension of court and the unpleasantness and the combativeness of court is not there in the mediation space. So that's the first thing. The second thing, in terms of the cost and the length of mediation, in certain fields, a strong statement of issues by each party is all that's really needed to mediate. I don't believe that mediators need to read 100 medico-legal reports. I don't believe mediators need to know every single in and out of a case. When I sit as a judge, reading obligations are absolutely overwhelming. And I will make sure when I sit in court as a judge that I will read every single word of every single piece of evidence. But in the mediation space, we're not there to judge. We're not there to say who's right and wrong. We are there to facilitate. And I believe that if both parties put forward a strong statement setting out what the matter's about, where the issues are, what the heads of damages are, what the evidence is, I believe that the preparation for mediation can be limited to an hour or two, not always, but in many, many cases, and I can tell you in 99% of cases in the personal injury field, most certainly, all you need is a statement of issues. So in terms of cost of mediation, if you can put forward a strong case, set out very well in writing, I don't believe mediators need to study the pleadings. I don't believe they need to study the expert evidence. Bearing in mind they are there taking a facilitative approach, a strong statement from both parties will limit mediation preparation to an hour or two. And very often the mediation itself is taking no longer than 2-3 hours. Again, if it's a very complicated matter, it'll probably take the better part of a day. But I have sat in medical negligence mediations, which have been complicated, and the quantum involved is many, many, many tens of millions. And the mediation has taken a couple of hours. So I think it's so important to point out, because attorneys are worried, what are they going to be spending on the mediation? It's so much cheaper in terms of preparation. The attorney is doing the preparation. So the mediators or the cost that you are paying for the mediation itself is insignificant in comparison.
I've got one last question, and Felicity, I'm keeping an eye on the clock. I know that I need to hand back to you in a moment, but a question for any of the panelists, or any or all of them. But I've heard a few of you have talked about the whole point about interests and mediations and the settlement focusing on trying to satisfy parties' interests in a way that might not be satisfied through litigation. Just picking up what we as lawyers do at the outset, is it acceptable? Maybe it sounds like this is a closed question, but is it acceptable for lawyers to take instructions and formulate a cause of action and then run at it as hard as they can without spending an equal amount of time with the party understanding what their interests are? Lee.
Yeah.
Oh, Patrick, you jump in on that one.
Yeah, and I think it's a very good sort of pointer to take, is that, unless you really understand what's troubling your client, what is it really that's going on here? You're saying you want this and that, and these are your rights, and so on. You could do them a serious disservice by not understanding what they really need. And that's what those interests are, the underlying interests. the positions, as Tefo, correctly said, are what we see out in the open, the kind of my position, your position, the kind of backwards and forwards, attack, defend kind of retaliation phase, the cycle of it. But underneath it all are different issues operating, which they employ those tactics, those visual tactics, to hide the underlying ones. And if a lawyer doesn't understand what those are, I think the client would probably end up being disappointed by the outcome of the litigation. I think would have done their client a disservice and not a service.
Well, to be fair, I mean, we as attorneys we trained to do exactly what you are asking whether we should be doing. We prosecute our clients' case to the best of our ability, and it's not all attorneys that can distinguish between positions and interests. If you know what I mean, we know it because we've been trained as mediators and so on. So it's a bit of a slightly unfair question, I think, Chris, in that sense. But of course, for a mediator attorney, I think it would be sacrilegious not to deal with the issue of your client's interests, fully knowing that there is such a concept. And I guess the only way to mitigate the situation is for mediators to be introduced into into these disputes much earlier than not. That's, I think, the best, what can assist.
Lee, a last word, if I can offer you one.
I'm going to be, what's the expression amongst the pigeons? The cat amongst the pigeons. Again, in certain fields of law where you are dealing with damages that are payable and you're dealing with compensation, what is being found is that the client whose interest you normally want to analyze, and there's a lot of focus on protection of rights and what the interests are involved, we're finding a lot in matters where you're dealing with compensation or claiming of damages. We're finding that the client themselves is not really interested in the mediation process. They're interested more in the outcome. So still mediation is of huge benefit because you get an early chance at finalization. But it's interesting what's developed in different fields, because very often the clients are really interested in the outcome more than the process. But again, like I said, even there, mediation was shown to be effective. So,
well, thank you very much to all three of you. I mean, I think, Tefo, you asked earlier whether I wanted you to continue. I would like to have the conversation for 3 hours, but I think we might. I don't think many of our audience would be able to put aside that much time. It's been great talking to the three of you. Thank you so much, and I hope, Felicity, that you will allow us to have more conversations like this. Thank you very much.
Thank you, Chris, and thank you, colleagues. And yes, we want many more conversations like this because we're well aware that attorneys, advocates have their understanding of the world, and the mediation overlay is there's a different language, as Lee says. There's a different process. It's about interests, not just positions and merits, legal merits. So we are embarking on an effort to share with particularly the legal community a deeper understanding of mediation. We're going to be running quite a few more of these webinars, but also some mediation advocacy sessions, which involves helping representatives understand mediation so that they can represent effectively in mediation and become proponents of mediation, ideally. And this is what we call mediation advocacy training. So we'll send a note out on that. Of course, training as a mediator gives you a very clear sense of what mediation is. And so often the legal representatives who join us for mediator training come away saying, it's a mindset shift and I've changed in so many respects. And then lastly, use mediation and talk to us about your clients' needs. We're happy to offer no obligation calls with you, your clients, with our mediators or with any one of us on our team to understand mediation and to meet the mediators, so you have a sense of who you might be working with. But thank you everybody very much for joining. I hope you've been able to see all the chat going on. There have been quite a few comments and answers in the chat and also in the Q&A, and we will see you soon. So thank you for your attendance.